Hi, and welcome to the Complaining Cow Consumer Show with me, Helen. And today I'm really delighted to have with me Amanda Hamilton, who's the former CEO and now patron of the National Association of Licensed Paralegals, which I think is going to be quite interesting. So, Amanda, welcome and thank you for joining me.
Thank you very much for inviting me, Helen.
So, what is it that the National Association of Licensed Paralegals does and your role in that?
Well, what we are is a professional membership body for paralegals, as well as being an awarding organisation offering nationally recognised qualifications for paralegals. My role has been sort of multitasked over the years. I started off about 15 years ago as the CEO. I've now handed the mantle over to a colleague. I'm very much a part of the day-to-day running, if you like, as a consultant. And I do things like this, interviews to try and promote our organisation and the paralegal profession generally.
Tell me a little bit more about what it is that a paralegal does and how it sort of differs from other legal professions.
Well, paralegals are lawyers, but they're not lawyers in the conventional sense, like solicitors and barristers, but they nevertheless can offer legal services to consumers. There are various provisos, i.e. things that they cannot do or step over the boundary of, which remain the monopoly of solicitors and barristers, and these are called reserved activities. Now, provided a paralegal sticks within their remit, they can offer legal services and advice and assistance to consumers on a wide range of legal matters, from debts to helping somebody through divorce, from employment matters, etc. So really their role is very similar to that of solicitors. I say similar because the solicitor's role, barrister's role, these professions are statutory regulated. The paralegal profession generally is not statutory regulated. And what we do within our organisation is to offer those professional paralegals a form of professional status by offering them nationally recognised qualifications, by offering them professional membership. And that in turn helps them and any potential client they may have with confidence and an idea that they are backed up by a fully recognised organisation.
So to tell me a little bit about some of the things that a paralegal may help you with in court.
In court, it's difficult because it depends very much on the nature of the case. Example, if somebody is being taken to court on what we call a small claim, i.e. Joe Bloggs says you owe them £8,000 and you feel that you don't owe that money, so Joe Bloggs takes you to the small claims court, then a paralegal can not only assist the defendant, the person who's being taken to court, by helping them with forms to fill in, but can, if the case does get to court, can represent you by advocating, standing up and representing you to a district judge in chambers. So that is one of the things that a paralegal can do. What they can't do, however, is to be an agent. In other words, like a solicitor can write letters on your behalf, fill in court forms and sign as a solicitor on your behalf, a paralegal is unable to do that because that is a reserved activity. It's called conducting litigation. And therefore, the paralegal can only assist an individual client in how to fill in the form, but the client themselves must sign the form before sending such a court form to the court itself. So in court, there's lots of things that a paralegal can do, giving moral support, giving advice how the process will be. And in some courts and circumstances, and I'm talking about the small claims court or even a tribunal, an employment tribunal, the paralegal can in fact stand up and talk to the court on his or her client's behalf. So those are the things that a paralegal can do, which is quite vast in itself when you think about it.
And can consumers claim for those costs of a paralegal when if they're defending themselves or indeed taking someone else to court?
Generally speaking, no. In a small claims court, there are generally no order for costs given. I say generally because in certain circumstances, and I believe there have been one or two cases where a paralegal, a client who was used as a paralegal, has managed to claim back costs. But generally speaking, there are no costs awarded. And that means, therefore, that the client themselves is responsible for paying the fees of that paralegal.
But presumably a paralegal wouldn't be cost as much as a solicitor.
Well, precisely so. The cost of solicitors and barristers these days could very well be outside of the pocket of most individuals. And we're talking generally a barrister, if you instructed a barrister directly, they would charge anywhere between, say, £200 and £400 an hour, depending on their seniority. A solicitor would charge somewhere between £250, £300 and £500 or £600 an hour. So that is quite costly. A paralegal probably will charge something in the region of £30 to £80 an hour, depending on what type of case it is. And quite a lot of the time, there may be a fixed cost for doing something for a client, you know, a package deal, if you like. You know, I can do this, this, and this, and the charge will be fixed at this cost. So, yes, you're quite right. A paralegal's fees will be far less than those of a solicitor and or barrister.
Where would somebody go if they thought, actually, this is a good idea, I want to get some help from a paralegal? What would be their first steps to getting one?
Well, there is a National Paralegal Register, and all you have to do is to search online for the National Paralegal Register. And that register will have all sorts of different types of paralegals with various specialist areas of law. Some, however, may only be what we call affiliates. They may be just studying law, but others will be associates, fellows, principal fellows, licensed paralegals. And so they are contactable through a contact form via that register if you are seeking someone to assist you.
Do sort of paralegals all specialise in one kind of area, or do they tend to be general?
That's a very good question. Mostly paralegals specialise in one or two or perhaps three particular areas of law. Some only specialise in one area of law. Others may be general practitioners that could assist you with a whole range of different legal subject areas. So the good thing about the register is that you can search for a paralegal by region. You can search for a paralegal by specialist area of law. And these days, really, it doesn't often matter where the paralegal is based in the UK, because a lot of things are managed online. But so mostly I would suggest that it depends, and the search should be by area of specialization, really.
Yeah. You talked about sort of representing people in court. I mean, some people choose to represent themselves in court and save any costs at all. What do you think would be the downfalls of that?
The downfalls are that most people have an idea of what it is to go into court. There are an awful lot of TV programs about courts, and a lot of them from the United States. So there may be misguided as to what happens in court. So the first thing that would strike one is that a litigant who is trying to represent themselves may not have the knowledge of how things are done, the processes, the court forms. And that is the first pitfall that they may come across. But not to worry, because there is an awful lot of help out there online. Even the Gov UK website has an awful lot of information for litigants who are planning to be in person in court. So there's a lot of advice and assistance that a litigant can gain, but it's going to be a struggle. And the other side of the coin is that judges will always be aware that one of the parties before them may be a litigant in person and may have to slow down proceedings to ensure that that individual is given the proper advice and is given the proper knowledge about what they need to do and so on. So that may actually delay the whole process in court. But there is nothing wrong in being a litigant in person. It's everybody's prerogative to do that if they can't afford paying the fees of solicitors, barristers, or dare I say even paralegals. But there's a lot of research really that needs to be done and a bit of knowledge that has to be gained. I could say that in fact there is one thing they can do, and that is be guided by what we call the civil procedure rules. And I'm talking here about civil matters as opposed to criminal matters. If a person is unfortunate enough to be prosecuted by the police in a criminal matter, then it is necessary to get a solicitor. But there are different rules relating to legal funding and legal aid in those circumstances. So we're talking primarily about a civil action where one individual does a wrong to another, whether it be owes them money, assaults them, whether there is an employment matter going on, a dispute over being wrongfully dismissed or anything like that. So these are what we call civil matters. And the one Bible I'm talking about is called the Civil Procedure Rules, and this is a guide to any kind of civil matter that gets to either the county court or the high court. When you go on to the civil procedure rules, it looks very official and the language is not always user-friendly, but it'll guide you as to what needs to be done. And there is plenty of information out there online. If you take one of the rules, for example, that you can't understand it as it is written, and if you were to Google that rule, there will be plenty of information in layman's terms about what that rule is and how to comply with it.
Do paralegals tend to help a defendant as opposed to someone taking someone else to court, or is it sort of equal?
Oh, no, it's both. You know, whether you feel you need to take somebody to court because, well, XYZ, they owe you £10,000–15,000 or something like that, a paralegal will be there to help guide you. Or on the other side of the coin, if somebody's taking you to court because they claim you owe £10,000 or £15,000, a paralegal will be there to assist you as well.
I've been a defendant. I've taken people to court, the small claims court, and it can be if you're not used to it and you're not assertive and you don't know. I've done it on consumer terms, so I've known my consumer rights. I think it can be very, very daunting for people.
It is indeed. Yeah. It is very, very daunting. It's not something that I would recommend somebody goes through. It's a very difficult situation you may find yourself in, and being, as you've just said, somebody who's been on both sides of the coin, the recommendation I would suggest is try not to get to court in the first place if you can help it. You know, this is very difficult if you're dealing with somebody who is very awkward and unreasonable. It may be difficult to try and approach them and settle something without the need for going to court. The other side of the coin is, are they claiming something that's worth defending? I'm thinking in terms of, you know, if there's a dispute with a neighbour over something, is it worth the hassle? They're going to be your neighbour. Are you going to promote good neighbourly relations by insisting on go to court, or they insisting you go to court? Of course, sometimes you're dealing with very difficult, unreasonable people, and there's no choice in the matter. But if it can possibly be avoided, then the recommendation is avoid it at all costs. The stress, as you well know, the cost, everything takes its toll.
It's so much time filling out all the forms and giving all the evidence.
Absolutely. It can take up the whole of your time for weeks on end, months on end, you know, and that's why you have to balance out. Is it worth it? Is it worth the stress, the time, the toll it takes, the cost? And these are things that you have to consider before even taking that step.
Yeah, I mean, quite often the threat is enough. Taking a screenshot of the money claim online site is enough to focus some people, but that's usually, for my case, it's big organizations, and I think for individuals it's very much more difficult.
It is difficult for an individual, and you know, you hear these stories, as you say, with large organizations. They deny it, they deny it, they deny it, and in the end you think, well, you know, I've tried my best to write them emails, letters to say, you owe this money, here's the proof, here's the evidence, and they're just denying. And the moment you start completing a claim form online and send them that, they say, okay, well, you know, we'll both just pay up.
Yeah. But I see it all the time.
Yeah, exactly. And, you know, it could well be that a lot of unreasonable individuals out there use this ploy with other individuals.
Yeah.
And what they're not expecting, of course, is for the individual against whom they're making the claim to fight back and put in a defense. They're expecting them to pay up or kowtow to what they want. Therefore, if you're in that position where a claim is issued against you through the courts, you've got to make that split decision quite quickly. Do I defend it, or do I just do what they want? And that's where all those elements come in. Is it worth the stress? Is it worth the time? Is it worth the cost? And that has to be balanced out, because I'm pretty sure that a lot of people do use that ploy, threaten court proceedings, issue a claim form, knowing you think that the other person will comply with what you want, and then realize, oh dear, they haven't complied, they've defended it, now we're in for a hiding, because once a claim is defended, it has to go through the motions. That's not to say you can't stop it at any time if a settlement is reached, but you get two people who are stubborn. One is defending out of principle, the other is attacking or making a claim because they're so totally unreasonable. And before you know it, you're in the throes and throngs of a full litigation process in court. And you'd have to see it through to the end. And that can sometimes take months, depending on the type of case, months and even years.
Particularly with the backlog at the moment.
Particularly with the backlog, as you say, at the moment, due to COVID and other matters. So yes, it's a very difficult situation to find oneself in, whether you are a potential claimant or a potential defendant. The suggestion would be from myself, don't go there if you can possibly avoid it.
You sort of touched upon it there, that people can make decisions or come to an agreement, before it actually reaches any court, and that that can be using alternative dispute resolution. And I know that the small claims process, you have to have shown that you've gone through that. Does a paralegal help their client with that as well?
A paralegal can help their client with that. We have there are plenty of paralegals out there that specialize in ADR, alternative dispute resolution, indeed, and can advise on that. But there are qualified mediators out there. And really and truthfully, you probably need somebody with a legal background to help mediate in a legal dispute. But, mediation is something you really have to go through during the court process. Once it gets to court, you can have mediation at any time, at any point, preferably sooner rather than later, because the sooner you can settle something to both parties' agreement to compromise, the better it will be, clearly, because you save yourself an awful lot of costs and time if it continues. But even before the process starts, even before a claim is issued, and this is where courage needs to be taken on board, the courage to approach the person who is the aggressor, the person who is unreasonably making a claim against you, the courage it takes to take a deep breath, knock on their door and suggest to sit down and discuss it, that takes a lot. But surprisingly, no matter how you feel about this person who is threatening you, and I use the word in inverted commas, not with violence, but with court action, although it could be the other way, I guess, but that would be a different type of case. But the moment you confront somebody and say, come on, let's sit down and discuss it, you will find that in 80% of the cases, the person will say, oh, all right, because they're so unexpectedly, they're not expecting this at all. And then there may be a settlement, an agreement reached without it going any further forward at all. So that takes a lot of strength, I think, and courage to do that, especially if the other person has been totally unreasonable in their approach to everything.
How often do you see that working?
You mean the approach person to person, face to face?
Yeah, and maybe a sort of more on the whole mediation thing.
Mediation is a very good process. And for the most part, from what I can tell and from what I have heard, mediation has worked in 75% of cases. It doesn't always work, but that again depends on the individual parties concerned. Mediation means that the parties have to find some kind of compromise where they're both happy. And that requires, people to sort of say, okay, I'll give in to this extent, or okay, I will only accept this. And a mediator's job basically is to either get the parties to sit opposite each other around a table and discuss it face to face, or alternatively, to run between one party and the other with various offers of compromise and so on and so forth. If you get a really good, experienced mediator, they can usually find an answer to the problems and to the satisfaction of both parties. But again, that really depends on the stubbornness and the willingness to compromise on both sides.
And will a paralegal help the consumer with what's being proposed as well?
Yes, a paralegal who's definitely got experience in mediation or some ADR experience will be able to, say to their client, look, unless you want this to be pursued through the courts and you're determined to pursue it through the courts, which will take up stress and time and cost, I would suggest you take a think about what's the minimum you would expect from the other party. And let's come up with some kind of offer or compromise for them to consider. It's always best to have somebody there who knows, whether that be a paralegal or that be a direct access barrister or somebody there who can guide you. Because otherwise, when you're heavily involved, as you well know, in the action or the potential action, it's very difficult to make an objective decision about what is compromise, whether you're giving in too easily, whether you're giving them too much and not retaining much for yourself, and so on.
Yeah, so what's fair?
Exactly. Yes.
What do paralegals tend to stay as paralegals, or do they go on to do something else? What's the sort of general sort of career pattern for a paralegal?
It can be both. Basically, a lot of paralegals do paralegal work as a stepping stone to qualifying as a solicitor or a barrister. But there are many, many paralegals out there that what we call professional or career paralegals, that whether they work for an organization or a law firm, want to just stay as a paralegal, in which case, of course, they are generally assisting a senior person in their organization or firm. But the others, those who want to retain their paralegal status, usually a lot of them, after some years' experience, will branch out and open up their own paralegal practice, offering the services that I've described previously to their own clients, to consumers. And this is a really, really good thing, Helen, because As you know, access to justice at a reasonable cost is very hard to find.
Absolutely.
Especially since legal aid was virtually eradicated some 10 years ago. Consumers need that access to justice, need to be able to know that they can afford some kind of legal assistance. So there are many more paralegals now branching out in that direction, I'm very happy to say. I'm happy to say both for the fact that there is now a separate legal profession in its own right for these individuals to consider, but also for consumers and gaining that access to justice at a reasonable cost.
Absolutely.
And I'm sure you would agree with that.
Yes, absolutely. I mean, that's part of the reason of having you on, because obviously I can help sort of consumers with the consumer rights, but that is absolutely where my expertise starts and ends, and it's sort of self-taught. But I mean, anything else, I say to people, you've got to go and get specialist advice, and quite often you're going to have to pay for it unless you're going to a no-win, no-fee solicitor.
Yes, exactly.
Which is a whole different kettle of fish.
It is, yes, it is.
All sorts of other issues. But yeah, so I have found that really interesting, because I have to say I didn't know a lot about paralegals. So I hope the audience have found that really interesting too. So can you tell me where people can find out about your association and more about paralegals?
Yes, well, our association, you can find them online, nationalparalegals.co.uk. As I say, we offer professional membership, and to our most experienced members who are associate or fellows or principal fellows, we offer a license to practice, which basically means they've been through hoops to try and gain that license. We don't just grant a license to practice to anybody. There is a lot of due diligence done on these individuals. Necessarily, as a consumer, you don't need necessarily to have somebody who's a licensed paralegal. You just need to know that they have experience in this area of law and can advise you. A license really is for those who do want to set up their own practice and do want to serve the community and consumers generally. And it offers backup confidence for them. And as I said earlier, for a consumer to know that this paralegal is licensed, gives them security, gives them confidence in using this individual. And there is a comeback, because every licensed paralegal has to have professional indemnity insurance. But more importantly, there's a backup of our organization if there is a complaint about any individual, and we can sanction them in various different ways. So my advice to consumers out there is that if you do seek the assistance of a paralegal, make sure they are a member of an organization such as NALP, National Association of Licensed Paralegals, in the first place. Make sure that they are qualified or experienced and have the competency. And if they are licensed, you need to know that every licensed paralegal out there needs to have, before they become licensed, professional indemnity insurance, which adds another level of security for a potential client. So nationalparalegals.co.uk, that's where further information can be sought.
Well, thank you. That has been really interesting. And so thank you for listening. And if you have a topic you'd like me to discuss on the show, you can email me on helen@eastlondonradio.org.uk. And thank you again, Amanda, for your time.
You're very welcome. It's been a pleasure, Helen.
Thank you. And you can find me on the website, thecomplainingcow.co.uk, for information on consumer issues, including rights and money-saving matters, and all the other episodes of the Complaining Cow Consumer Show on East London Radio. And you can find me on Twitter @ComplainingCow and @TheComplainingCow on Instagram and Facebook. And you can get 15% off the books, How to Complain, the Essential Consumer Guide to Getting Refunds, Redress and Results, and 101 Habits of an Effective Complainer. Many thanks. See you next time. Bye.